The Honorable, the Supreme Court.
Good morning, everybody. Good morning. Thank you very much. Please be seated. When you're ready, before we start, I want to welcome the students here from Burlington. Yes? Yeah. Oh, Steve, there you are. Attorney Ellis, nice to see you. Welcome to all of you. It's a pleasure to have you here with us this morning. So having said that, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Central Vermont Medical Center, fiscal year 2025. Case number 24 AP 326. Representing the appellant, Central Vermont Medical Center, is Shapley Smith. Seated at counsel table with Attorney Smith is Alex Hunter. Representing the appellee, Green Mountain Care Board, is Ryan Kane. Seated at counsel table with Attorney Kane is Jonathan Rose.
Thanks very much. Counsel? And for the record, before you start, if you would introduce yourself and identify your client.
May it please the court, my name is Shap Smith, and I have the pleasure of representing Central Vermont Medical Center today.
Thank you.
We ask the court today to hold that Green Mountain Care Board must follow the law and establish and adhere to clear regulatory standards in its decision-making process. More specifically, we ask the court to conclude that the GMCB, the Green Mountain Care Board budget process, violated Vermont law in two critical ways. First, by failing to adopt, disclose, or adhere to legally required standards during the budget process, the Green Mountain Care Board acted in an arbitrary and capricious manner, such that its budget order should be voided as a matter of law, vacated, and remanded. Second, the board violated Central Vermont Medical Center's procedural due process rights by failing to articulate clear standards in advance of and during the budget process.
Can I ask a question about that, Attorney?
Certainly.
My thought about that is the hospitals go in front of the Green Mountain Care Board every year. And I just find it difficult to believe that after doing presentations year after year, they don't know what it is that they're supposed to be proving at those hearings.
So, Your Honor, I think it's important to talk a little bit about how the process works to answer your question. I think it's a fair question. So each year, the hospitals and the Green Mountain Care Board work together to try to agree on the metrics that will be used and for the budget setting process. It is a back and forth, and the hospitals, through the Vermont Association for Hospitals and Health Systems, have consistently and persistently asked for some sort of standards that will be associated with the metrics that the Green Mountain Care Board has identified will be things that they look to. So, for example, and this was in our brief, clinical productivity and the question of specialists. They identify that they will look to peer groups for what the proper clinical productivity is for specialist groups, but then they don't identify a standard within that peer group which to meet. And we're not asking.
And I know you've pointed out certain issues that you have with the process.
Yep.
But isn't the case law that we look at the overall decision rather than look at it piecemeal?
So the question, I think that it's a little more subtle than that, I think, in what we're saying is that it may be that once the standards are adopted, the appropriate standards are adopted, that the Green Mountain Care Board's decision should be what it found. Our argument is that we don't know what we should be shooting towards during the process or even before the process starts. We don't have a range within any of those metrics that have been identified to suggest where we should fall within that range. And it's definitely true that there are a variety of different metrics that are going to be considered during the process, but that balancing of the metrics is difficult because we have no idea where we're supposed to be.
And with respect to the metrics, if I read the papers correctly, the care board identified 95 metrics that they might consider, didn't tell you which ones they were going to or not going to. So that's a predicate? Am I right so far?
That is correct.
Okay.
Yes, Your Honor.
So my next question was, had any of these metrics been used in the prior budget process?
I believe that the metrics have been, there have been different metrics that have been used in prior budget processes, some of them similar to the ones that are used in this particular budget process. And then others that, it's adaptable over time as the regulatory process moves forward. There are other things that may need to be considered.
So,
Let me just-
so Mr. Smith, let me follow up on the questions of my colleagues. 18 VSA 9456E gives the board broad discretion.
Mhm.
And the board, and you just mentioned the clinical productivity, the board cited to specific information provided by the hospital. For example, your data on clinical productivity, the long wait times, Medicare payment to cost ratio that existed at the hospital. Are you saying that's not enough to satisfy the burden of being specific enough so that you can figure out how to budget?
So what we're saying is that while those may be appropriate measures, the board needs to identify what the range is for where they expect the hospitals to be. And the challenge here is actually it goes a little deeper because it's not, in certain circumstances, they identify these metrics to be you're supposed to be compared to peer group hospitals. And the peer group hospitals were never finalized in the guidance. So we're not sure whether and what we're going to be compared to with regard to those peer groups. And then in the decision, particularly with regard to the productivity, they don't identify, they actually don't compare us against the peer groups. The information that they asked for and that we provided to them was how we compared to national hospitals. And the Green Mountain Care Board itself recognizes that different hospitals within the state should be compared to different types of hospitals. For example, Copley Hospital in my own hometown is a critical access hospital. The measures and metrics for Copley Hospital will be different than they might be for Central Vermont Medical Center, and they are different than the ones that might be applied to the UVM Medical Center.
So should they be required then to draw up a set of metrics for each hospital that's coming before them for the budget process?
Our view is that if they are going to separate into separate peer groups, they ought to identify for the peer groups the standards to which they are going to be held. We're not asking for a set number. A range would be appropriate, but we need to know where we're shooting towards when we're actually putting together our budget proposal.
But you were given a higher NPR rate than what was asked for by the Green Mountain Care Board. So obviously you had the ability to produce good evidence on that.
Well, it is true that we were provided a higher NPR, although it's not clear why that number was chosen from the decision. It could be seen as sort of a compromise number, but there was not any explanation for why that number was set. And this actually goes to sort of a broader thing. I mean, I want to acknowledge, I think that, the backdrop is important. The healthcare system does have significant challenges, and difficult decisions are going to be made. And in that context, it's important for the regulated entities and almost more important for the public to understand how those decisions are made. And in making sure that people can understand that, they need to see standards for how the decision is made. And that isn't the case in this instance. And it isn't the
Mr.
case
Smith, but
throughout the process.
doesn't the board have a responsibility to control costs? I mean, it's part of the mandate, the Green Mountain Care Board, to control costs and look at the issues that go into each individual facility to determine how and what ability to increase either the commercial rates or the per player rate.
So the board actually has a number of things that it must consider, and it's not just controlling costs. It is controlling costs, ensuring quality, and also ensuring access. And there are other rationale or things that the legislature has identified should be considered by the board. So there are competing factors here. And I'm not saying that there is going to be a specific formula that you spit all the data into and then there is something that's spit out. But in the balancing of factors, we need to understand sort of what is acceptable within each one of those metrics that have been identified. The other challenge here is not just that the metrics, there's 95 metrics. The board reserves for itself the ability to consider other things that have not been previously identified. And so you'll see in our brief and you'll see in the decision for the budget that there are it refers to staff presentations that happened after our budget hearing. It refers to studies that were considered by the board after we had put forward our budget in July 1. There's the Bartholomew and Nash presentation. So what the challenge that we have here is that we need more guidance than has been given for us to have a regulatory structure that is consistent with due process principles and allows us to understand a decision that is being made. I have reserved some time.
Can I ask you one question before you sit?
I would never say.
So the amicus brief says that the FY25 budget relief is impractical or impossible as of right now, based upon its connection to insurance premium rating cycle. In other words, I think they're suggesting this is moot. Have you got any position on that?
Yes, we do, and we addressed this in our brief, in our reply brief, Your Honor. The statutory scheme for a hospital budget review clearly contemplates that a hospital budget can be adjusted during the year, and the notion that that it's moot when the actual statutory language makes clear that you can adjust mid-year, I think forecloses the argument of mootness.
Thank you very much. Thanks. We'll hear from counsel for the appellee, please. And as usual, if you would introduce yourself and client before you start.
Thank you very much. Good morning, Mr. Chief Justice,
Good
Your
morning.
Honors. And may it please the court, Ryan Kane on behalf of the Green Mountain Care Board.
Thank you.
Be arguing 4 points for the court today. First, the board's decision was guided by and grounded in sufficient standards from the legislature and established in the board's own guidance documents. The board exercised its discretion reasonably based on those standards. The hospital had sufficient notice of the nature of the proceedings to satisfy due process. And finally, to the extent there's time left over in questions, there's no statutory obligation to require net patient revenue on a per capita basis, as CVMC argues here. I think.
I'm sorry to cut you off right
Please.
away.
No.
Can you respond to the mootness question that the Chief Justice asked?
We didn't argue
Yeah,
mootness in our
I know.
brief. I think there are a couple, there are short timeframes by which these budgets are developed every year. The legislature's mandated that the board establish each hospital's budget every year. So whether it's through an opportunity to amend the budget during the course of the fiscal year as a result of, say, a decision from this court adjusting the board's decision, or under a capable of repetition yet evading review analysis, I think we're not arguing that it's moot.
Thank you.
Although practically there are some indications that it could be, given the timing of a decision from this court vis-a-vis the FY25 budget.
Since you've already been interrupted, I'll.
Please.
One of the complaints that the hospital is making is that there was no standards for the application of the 95 metrics that have been identified. Isn't that something that A, should be, they should be entitled to have, and B, is not difficult to do?
I think the answer to both questions is no. First of all, the 95 metrics, as Attorney Smith articulated, there is a process by which that guidance document that sets the framework for budget analysis each year is created. And it was during the course of those discussions, that interplay between the Hospitals Association and the board, that those were first mentioned. And in that context, it was clear, that's not in the record of this case, but it was clear that these were items that the board considered relevant to address the key criteria and key factors that it must consider under the statute. It was never said that these are going to be benchmarks. The statute gives the board the authority to, in its discretion, establish benchmarks, as it did for net patient revenue and as it did for the commercial rate cap. But there's no requirement that the board set benchmarks for each and every one of those things. And the fact that they articulated, here are some relevant information to present to us with respect to some of these factors like efficiency, affordability, access to care, doesn't mean that the board then has to establish a benchmark for those, especially given, as Justice Carroll's questioning indicated, the difficulty in doing that, given the disparity, like the differences between hospitals in the state. I think fundamentally it would require essentially saying, for each hospital, here's exactly the range of things we're going to look at for each benchmark we want to consider, which then ignores the necessary interplay between these benchmarks. Because as we've discussed yesterday, that the process looks holistically, not just at each hospital, but the interplay between the services at each hospital, as well as the system-wide and statewide administration of healthcare. So attempting to establish benchmarks for each and everything that the board would consider is impractical, and it would ignore like the interplay between them. Some things, we talked about cash on hand yesterday as being an indicator of financial stability, but that can mean very different things based on different hospitals. A network hospital like UVM Medical Center or Central Vermont Medical Center that's part of a bigger hospital network, if they have very little cash on hand, that might not be a problem. But an independent hospital might require more cash on hand. At the same time, too much cash on hand, if you're sitting on, a full year's operating budget in cash, that's not good for the system. That's not good for ratepayers. So the interplay between the metrics, the specificity to which they're applied to each hospital makes setting benchmarks for each of those things impractical. And additionally, some of the things that are articulated in those 95 metrics are just not subject to setting, some deal with demographics, the kind of interplay between payers at an individual hospital, which the hospital may have no control over, and are just things that indicate that could be used in that broader analysis that the board has to do. But fundamentally, the legal standard is the exercise of the board's discretion guided by sufficient sort of guardrails and guideposts by the legislature? And if it is, then the exercise of that discretion is constitutional and is lawful. And the CVMC concedes, I think, in their reply brief that the legislatively established standards and guidance are sufficient to direct the board into how to accomplish the broad, system-wide, statewide goals that the legislature has directed it to do.
So let me interrupt you if I might. The board set a target, which was what for the patient?
The net patient revenue benchmark was 3.5%.
And ultimately, they agreed to what?
Ultimately, they agreed to 6.1.
Okay, so Are these numbers, these percentage numbers, are they caps? Are they, do we understand, is there something in the law that says these are caps that the hospital is expected to work within and perhaps even come under these caps? Or are these expectations that are very specific to say to each of the hospitals, this is what you must do?
The former, it is not a this is what you must do. And that's explicitly articulated in the guidance document that was at the start of this. The board acknowledged that this 3.5% growth in net patient revenue may not be the appropriate growth target or the appropriate ultimate growth level established for their revenue for every hospital, but also then explicitly articulated what the hospital must show to justify going over that.
And how does the board come up with the original target number? What's the process it engages in?
There's a public process where the Hospitals Association and I think other players in this
Is this
realm.
where the public hearings come in?
That's later, although there may be some opportunity. The ratepayer advocate, I think, is part of the establishment of the guidance. I don't know that there's a just pure public comment opportunity for that, but there's a separate process at the outset to establish that guidance document.
And is there
nobody has
some
challenged
economic
that here.
calculation that the board engages in before? I'm talking about the original target number is really what I'm focused on.
Yes, I mean, I don't think it's as simple as a formulaic thing, because I don't think any of these considerations lend themselves to just strict application of formulas. So it looks at growth rates over the past years. It looks at hospitals' compliance with those benchmarks and with the budgets established. Are a lot of hospitals exceeding revenue?
And to what
caps?
extent does the target that they ultimately come up with, to what extent does consideration of that number and its potential impact on insurance premiums, health insurance premiums in the state, come into their calculation to set a target number in the first place?
No, I think that's exactly one of the considerations that goes into the setting of that number is the overall affordability of healthcare in Vermont, ensuring that.
How do they do that?
Yeah, I don't know the answer to that question. There's a lot. It's very complex.
That's a
But
problem.
that 3.5 number that was established in the guidance, nobody's contested that. That's not, I don't think, an issue in this proceeding. But
Mr. Kane, is it too complex where people can't even understand it?
No, I mean, certainly the hospitals, I think, understand sufficiently the nature of the board's goals and the obligations to maintain costs. They're complex players in this game as well, and I think they understand it. Whether I can understand with specificity how exactly these competing interests are balanced and the metrics and the numbers and the interplay between all these things, I'll never suggest that I fully understand that. But that's why the legislature has created this board with expertise, with doing this every year for each hospital, that's able to develop that really complex and nuanced understanding and is able to try to keep the state of Vermont's interests, the administration of healthcare statewide, at heart in every decision it has to make, including establishing each hospital's budget.
But if it's too complicated and nobody can understand it, which I understand your position regarding the board having expertise, would that make it unworkable?
I don't think so. And this court in the MVP Health case, 2016 PT 111, cited in the brief, already articulated that the legislatively established goals and standards for the work of the Green Mountain Care Board are general, are open-ended, but that reflects the practical difficulties of establishing more detailed, narrow, and explicit standards in this field, a difficulty due to fluidity inherent in concepts of quality care, access, and affordability, given advancements and setbacks in technology, medicine, employment, and economic well-being. So this court has already recognized that those are the fundamental concerns. They are complex, yes, but that's why you have the Green Mountain Care Board.
Well, if I could, if I could interrupt here again, one of the things that I think we all have concern about is the health, not no pun intended, of the healthcare system in this state right now. And I wonder whether or not one of the concerns that is raised by the hospital here this morning and the Rutland Medical Center yesterday has to do with the public's appreciation for the critical state in which our healthcare system is today in this state. You know, isn't it important in that context for there to be sufficient accountability, sufficient detail about the process that is engaged in for the public to really come to grips with what it is that's happening. I don't know if that's an issue that's before us, but I think it is context for what we're talking about.
I agree, Your Honor, and I think that the board's decision, if you read it, fully satisfies that goal. It articulates with specificity the details of the affordability crisis in the state. It details the role in which hospital spending plays in that overall system, and it explains exactly why the Green Mountain Care Board is required to make some tough choices with respect to the ever-increasing growth of aggregate spending and price in the 14 hospitals in the state. So I think the decision details that problem and how the board is addressing it. But I think the nature of that problem weighs strongly in favor of the discretion of the Green Mountain Care Board to make those tough decisions as the legislature has
Well,
tasked it with doing.
Listen, I absolutely agree that the statute, the enabling legislation here, is broad in terms of affording discretion to the board, and it makes perfect sense for that to be the case. But there are questions that I have in the back of my mind about why is it, for instance, that as I think we saw yesterday, and I'm not sure if it's in this record, so forgive me if I'm pulling in a different record, but the access to hospital care in Vermont is so much higher than it is on a national basis. It's huge in terms of the percentage. It's something like I don't want to use terms I can't recall, so I won't say it. But you know what I'm saying, Mr.
I do.
Kane. You were here with us yesterday. Why is that, and how is the board addressing that? I guess would be the question I have here.
I don't have an answer to the question of why that particular piece of Vermont's affordability crisis has developed. How the board is addressing it is through the decisions it's making,
Yeah.
which do in fact cap the revenue or lower the growth of revenue. I mean, that's what we're not talking about. The revenues are still going up. And I think importantly, specific to this case with respect to the board's analysis, which I heard Attorney Smith just say that he contests whether the board's articulation of its decision was sufficiently clear, but I didn't see that issue actually raised in any of the briefing. But it is clear. I mean, the board said you have, and there's no exact benchmark on clinical productivity, but they don't contest the board's finding that their clinical productivity at CVMC is very low, and that they have long wait times, second longest in the state for some brackets there. So if you have people waiting a long time to see doctors, and you have doctors who half of which are in the bottom 25% of productivity, that is a problem. And that is a reason by which the board can say, we're not going to allow you to increase your revenue. If you want to keep the margin that you make, you can do so by increasing productivity, see more people, have greater clinical productivity and efficiency, and still make the money that you say you need to make. And that maybe requires some difficult decisions for the hospital, but it's the board that has to make those difficult decisions.
Revenue, reduce the wait times?
Sorry, what was that?
With increased revenue, giving more revenue to hospital, reduce the wait time for specialists.
They have no incentive to reduce the wait times if the status quo that they proposed in their budget and the increase, the 11 some percent that they requested an increase in revenue, they would have no, reducing wait times wouldn't necessarily increase their revenue, but it would increase their margins in that if they kept the same amount of revenue, but were more efficient, they're just going to make more money. What the board is saying is you don't need as much revenue, but you can be more efficient and still keep that gap between what you're spending and what you're bringing in sufficient to allow the hospital continue to operate.
I realize your light's on, but I have a quick question.
Yeah.
Doesn't the board's ability to consider other relevant factors, close quote, amount to unfettered discretion for the board?
No, Your Honor. I think this belies a fundamental misunderstanding or misinterpretation of the information that's relied on and the standards. And throughout the briefing, they conflate the two by saying, we didn't know the analysis. We didn't know what facts you were going to pick out of the record and rely on. And decision makers always are judging which facts are credible, which ones are important, which information is necessary to rely on. So this broad, system-wide, statewide look at the healthcare administration requires the board to be able to consider facts that the hospital may not benefit CVMC to point to regional or statewide trends that might mitigate against granting them stuff. So the board has the authority to consider information. And to the extent that it was suggested that the board considered things that were never disclosed, I think Attorney Smith's own recollection of that, they were disclosed. All of these public hearings, the Bartholomew and Nash, the expert study, it's an open process. Those were articulated, but it needs the ability to take in whatever information it needs in order to exercise discretion consistent with the standards. So as long as the standards are sufficiently clear to give those guardrails and guideposts to the board in doing this difficult task the legislature has given it to, the information that it relies on doesn't either expand or detract that discretion.
Okay,
Okay, thank you very much.
thank you very much. How much time does the appellant have, please?
Appellant has 2 minutes and 26 seconds remaining.
Alderman.
So, Mr. Smith, before you start, I want to follow up just on what Mr. Kane had said.
Certainly.
So he identified factors that the board considered, like, for example, the long wait times, the specialty doctors performing below 25%. And those factors are uncontested. Isn't that correct?
So he identified those metrics and that they were identified in the budget order. Our concern is that let's talk about the productivity numbers for a second. Those are national productivity numbers. We were told we were going to be compared to our peer groups. So there's no identification of whether those wait time or those productivity numbers are consistent with the peer groups that have been identified as the ones that we're going to be compared to.
So, for example, the finding that nearly 70% of the doctors were performing below the 50th percentile from the hospital, that is based on the national, not the peer group.
That is compared to national data, not peer group. And that's the concern that we have. So I have 3 points that I'd like to make, okay? First of all, to your point about asking about the overall benchmarks, they set them. None of the hospitals in Vermont met all 3. So all of them were subjected to a process that was standardless from our
Isn't
perspective.
this part of the problem the state has right now? I mean, is it evidence of that, or is it evidence of what, it's probably both, isn't it? Evidence of what you're arguing and evidence of the problem the state has.
I think it's a challenge. There's no doubt that we have a healthcare system challenge as a whole. I feel it at a very personal level, being married to a primary care provider.
All right.
But what it leaves open is whether the benchmarks themselves are actually appropriate. But we didn't argue that question. What we argued and what our concern is, what happens when you don't meet those benchmarks? And I believe Attorney Kane said standards are understandable or something to that effect. Our argument is that we haven't been given standards that are understandable. And let's be honest, when we make these budget decisions, they're decisions within not only the hospital community, but the community at large. And we have to make difficult decisions. If we have standards for the metrics, a range that we're expected to meet, we can go to our community and say, here is what we've been asked to do by the Green Mountain Care Board. Here's the range. And these are the decisions we're making because that's what we've been asked to do. We're not given that kind of guidance when we are going through the budget process. The last thing I'll just say is that despite the pronouncement from my colleague who's done a great job. This is a black box. This is not an understandable process. 95 metrics without any sort of guidance as to the range that we're supposed to meet does not meet the requirements of procedural due process. It just doesn't. And if we are going to be expected to put together budgets that are going to address the difficult situation, we need to understand what's expected of us. And we are not given that opportunity here. Thank you very much.
Thank you very much. Please call a conclusion of the hearing.